Great. All right. Good morning. It is January 7th. We're in Senate Judiciary, and we are starting off with S209, which was introduced by Senator Bohosky and a number of others. And we'll have Senator Bohosky do an introduction, and then we'll hear from Rick to provide us a walkthrough and take it from there. So Senator Bohosky.
Wonderful, thank you. So this is, dare I say, a fairly simple little bill. We currently have a law on the books prohibiting civil arrest without a signed judicial warrant in courthouses. And what this law proposes, or what this bill proposes to do, is to expand that to include state and municipal buildings, schools, shelters, and healthcare facilities to that list of places where civil arrest would only be allowed with a signed judicial warrant. And the sort of thought behind this is those are all places people might have to go and should be able to do so without fear of being snatched.
And just to clarify, civil arrest, obviously different from criminal arrest.
Yes.
And well, actually, that's probably a question for Rick that I can expound on. Anything else?
No, all I'll say is, in the op session, I did a lot of digging with our legislative council and the ACLU and others for ways to protect Vermonters and make sure that they have access to essential services. And this was one avenue that I saw that we could do that.
Okay. Any questions for some of those?
No, I'll wait for the walkthrough.
Sounds good. Almost called you Senator. Rick, could you go into
High praise.
Is that a privilege you're hoping for?
Less pay. So
Yeah, much less.
good morning, Rick Sagel, Office of Legislative Council. To see you all again. I'm going to share my screen here for S209. And as Senator Post said, it is a simple bill as far as the change to the law. There's a bit more background that I'll talk about. In fact, let's talk about the Bill Act 153 that was 2022. You may remember this one. This initially codified this idea of civil arrest protections in courthouses. There's this common law idea that when you go to court, you should be protected from a civil arrest. Some states have codified it. Vermont has now. Some states haven't, but it comes from England actually, where.
Rick, I'm sorry. Just before we start going forward, can you just clarify what is a civil arrest and how is it differentiated from a criminal?
Yeah. So it's kind of an oxymoron, right? You don't really associate civil cases with arrests, and they're not common. So a civil arrest would be, a contempt of court, where you're in the court or you are supposed to appear in court and you're not there. So the judge says, bring this person to the court, right? That would be an example of a civil arrest where the law enforcement comes and literally brings you to court. You're under arrest in that you're in police custody during that time, but you're not really going to be punished, right? Except for going to the thing you're supposed to go to. So I think a good way to explain it is not a punishment. It is a coercive act. It's meant to bring the person to the destination they were supposed to go to. In contempt of court, if you're in the courtroom and you do something that the court does not approve of, you can be in contempt and taken out of the courtroom and temporarily held, right? But a civil arrest is not a very common thing. It is not a citizen's arrest, and people think they're the same thing. They're not. In the immigration context, which I think is what this bill mostly speaking to, is the INA, the Immigration and Nationality Act, permits federal law enforcement, ICE, DHS, Border Patrol, to basically civilly arrest people to begin the deportation or to take them to the removal proceeding. That would be the point of the civil arrest in the immigration context.
So immigration arrests are considered under the umbrella of being civil arrests.
It is under the INA's deportation removal procedure, yes. You can be criminally charged with an immigration crime. That's not as common. That would require a judicial warrant. Each not require a judicial warrant, just a administrative immigration.
And if there was a judicial warrant, if it were passed into law, this would not prohibit the judicial warrant from being carried out.
That's right.
Okay. Please,
Oh, yeah, yeah, glad to give some background. So like I was saying, this Act 153 codified this idea that specific to courtrooms, that if you are in a courtroom, going to a courtroom, or leaving a courtroom, you should not be subject to a civil interest. And Vermont passed that in 2022. So S209, which is what we're walking through today, adds on to that law that was passed several years ago. On page 2, C1, this is the part of the law that was added in 2022, this prohibition. You'll see a person on line 9. A person shall not be subject to civil arrest while traveling to, entering, remaining at, or returning from a current law court proceeding is what is in the statute. Subdivision B is added to say state, county, or municipal building. Subdivision C, school. Subdivision D, community-based shelter, severe weather shelter, or emergency housing provided through 33 VSA Chapter 21, or a healthcare facility as that term is defined in 18 VSA 94-2. I have each of these pulled up in statute, so we can look at them in just a second. But this would be the additional places that a person would not be subject to a civil arrest unless there is a judicial warrant. And I'll show you that here. The exceptions do not change. In fact, this is the only part of the bill that does change is C1, adding those additional locations that are protected from civil arrest. So the exceptions are if there is a judicial warrant, you can still be arrested in not just a courthouse, but in a school, healthcare facility, etc. B is specific to a courtroom. So if you're in the court and you are in contempt of court, this does not get you out of that. You are still subject to civil arrest. And C, an arrest made in order for safety in the court if the proceeding is occurring. So no changes there. Subdivision 3A, the addition of C there is just a grammatical correction from the bill last time. A person who violates a subsection, and it could be an officer, it could be a non-officer, if someone tries to execute a civil arrest, a citizen's arrest, I guess, by knowingly and willfully executing or assisting with an arrest prohibited by that subdivision, shall be subject to contempt proceedings and may be liable in a civil action, false imprisonment. A person who is arrested, they bring a civil action. So if this bill were to pass as written, and if you're arrested in school, let's say, wrongfully, right, then you would be able to bring a civil action against the entity person that did this. Subdivision C, the AG can also bring a civil action on behalf of the state for relief if there is reasonable cause to believe that a violation occurred. No action shall be brought against the judiciary or any of its members or employees for actions taken to maintain order or safety. Again, this was passed originally just for courts. So the thing about that is that's one of the exceptions there, that you don't want to put a judge or a court employee in the line here. E, the section shall be construed to limit or infringe on any right, privilege, or remedy available under common law or any provision of law or rule. F, notwithstanding section, which I'll bring up here in a second, these protections and remedies afforded by the subject and applied irrespective of when the privilege against civil arrest is invoked. In fact, let me show you that one now, just because. So this 3578 requires a person inform the officer at the time of the civil arrest that they're invoking their right to be free from civil arrest. So this law, when it comes to the courtroom aspect and these other exceptions you're adding, you would not have to claim that privilege at the time of arrest. It could be later on. You don't lose your right to invoke your protection from civil arrest if you don't announce it right when you're being taken away by the officers. And then the definition as used in the subsection, civil arrest means an arrest for purposes of obtaining a person's presence or attendance at a civil proceeding, including an immigration proceeding. And the act would take effect on passage. I can bring up these definitions of the municipal or the community shelter, the healthcare facility, if you'd like.
Um, well, one quick note, I do think this might be a question for Beth St. James actually, but we may want to consider definition for school. And I think, you know, it could be very broad, the way it's written right now. Committee, any initial questions?
I do have a question about community-based shelter. Is there a definition for that already in statute?
There may be, but we're not gonna, at this point, it's not been cross-referenced. So if you want to define that, it would be helpful.
Yeah, I'm just wondering if, and maybe this is similar to the chair's question about school. You know, a community-based and shelter could be very broad. And I mean, personally, I wouldn't mind a broad provision because I don't like these arrests in any context of work. So, but it does seem maybe a squishy point in terms of the definitions.
That always can be more specific, especially when you're holding people civilly accountable for an arrest in one of these places. You don't want someone to be violating law when it's not clear that, you know, Good Samaritan is that, you know, an example, right? Is that
Right.
I would say yes, but that judge may disagree with me that this is not a community shelter. So I think more clarity would be helpful for the law, but you could also make it very broad. You could say, including this, if you don't want to be specific to a cross-reference.
Very much.
Yeah, I do have one question. I mean, a civil arrest in Vermont by law enforcement officers is basically non-existent as far as the criteria for this. So what we're saying here basically is the federal entities who are out there doing that now, are they working within the scope of the federal law when they're doing this?
So the INA, the Immigration and Nationality Act, does give federal law enforcement the right to civilly arrest people who they believe through an administrative warrant are in this country without documents, right? So you remove them or take them to their removal proceeding. So yes, that federal law does give them the authority to do that. Correct.
So what they're doing is illegal. Thank you.
What's the difference between an administrative warrant and a judicial warrant?
So judicial warrants are based on probable cause that has been reviewed by a judge, and the judge, based on their subjective opinion, believes that this is worthy of a person being arrested, right? That your Fourth Amendment is being protected. An administrative warrant is again provided. The INA has its own process for how these are issued. It's not a judge, it's typically a DHS employee supervisor that reviews the case and decide that we think this person should be brought to a removed proceeding. Not probable causes.
And thank you. Could you also describe what we as a state have to pass law that may affect immigration enforcement?
So yeah, immigration is one of those areas where it's mostly federal law, right? Federal government has wide latitude in regulating immigration law, but then the state has wide latitude in its police powers, right? How crimes are enforced to the extent that the state has sovereignty over its own borders important here. So the Supreme Court has not yet ruled on this specific type of state regulation. There have been some federal courts, specific to the courtroom. Let me be more clear. When a state declares its courtrooms to be, immune from civil arrest, federal courts have decided, for the most part, that that is a use of state power that's approved by the 10th Amendment that way. That the INA is just one thing that federal law enforcement is allowed to go in and arrest somebody civilly. But the state's also allowed to say, well, you can do that, but not here, right? We think that this aspect of our state, the courtrooms, state buildings, whatever you want to say, it gets a little bit gray, right? You can't say the entire state is immune from civil arrest. That would not be appropriate, but there looks to be some authority for the state to say, yeah, but we don't think this is an appropriate place for you to use your right to civilly arrest people.
Got it. So just to summarize, is it fair to say that generally speaking, we have the authority to create policy regarding how laws, the manner in which laws are enforced, but we don't have the authority to say whether or not laws can be enforced?
Yeah, that's fair.
Thanks. Any other questions, Senator Norris?
I do have, in reading through 209, and Senator Bohosky was doing her walkthrough, she had mentioned this was to protect Vermont residents. I don't see anywhere in here where it specifies, just says persons or persons. I guess I'd be looking for the definition under S209 as what is a Vermont resident? The follow-up question is under 3577 on page 1. Can you give me the example as to what this would or would not cover? This is somewhat confusing to me. You're under privilege from arrest. It's appeared to be elected officials.
Sorry, the page 1, the 3577, the subsection A. So this law is, I'm not sure when it was passed. It's been years. It's one of those laws where if you look at the statute, there's no date on it. So it's been on the books for a very long time. The courtroom provision was, like I said, added just a few years ago. So the history of the governor, you all, various state officers being immune from arrest, I can come back and give you more of a history because I don't know the history right now. But there appears to be some interest to protect officers, elected officials from when you're coming to the state house to be protected from arrest.
That's why they had to wait when they arrested Senator McAllister and wait for him to leave the building and step out to have a cigarette.
No,
Just long, I'd like no more history about it. It's just, well, we're not sitting up to protect ourselves here for some. Seems a bit.
So yeah, subsection A is
change to the law.
subsection A is
Antiquated.
totally unique to all these exceptions are to subsection C, which is currently the courthouse exception. Subsection A and B, in fact, are again, it might be 100 years old. I can go back and see how old these laws are, but subsection C is what all these other exceptions apply to currently.
But it does say the tenants on and in going to and return to the general assembly.
Actually, David Zucker got pulled over for speeding on his way to the state house and wrote this and then arranged to go and get his ticket later.
That's what I've often told. You can't be pulled over on your way to the state house,
Right.
but they can send you a ticket.
Yeah.
So it's not that you can just speak down the interstate and have no recourse whatsoever, but
Can't obtain.
they can't impede your way to the state house.
You also want to make clear that's not just civil arrest, right? The civil arrest is specific to this court issue. The subsection A is also criminal, except for felonies and what is it, breach of peace, treason, yeah. So it's a bit more protective of you all than evil on a court.
Any other questions?
I guess first part of the question.
Oh, sorry, I didn't know.
What's the answer? Who's this apply to? I heard Vermont residents, we're protecting Vermont residents. And it says nothing but persons in here.
Yeah.
What would be the definition of a Vermont resident?
So
Someone who's here or someone who's.
I wouldn't use that term because that's not the term we're using. A person would be any human being. That's what the statute currently is. So you can change that, but it's currently any human that is in either temporarily or.
Anything else? Okay. Any witnesses, this is a question for the committee or for Rick, if you have any thoughts, any witnesses that folks want to hear from regarding this bill? that we can add to the roster. We'll be, excuse me. We'll be working on the agenda tomorrow morning and starting to line people up for different bills. So if folks have any recommendations or suggestions for witnesses that they want to hear from, happy to hear.
And then it'd be helpful, given that I spent a lot of time in the off session working with the ACLU and a lot of this to hear from the ACLU.
Well, we're gonna broaden the list a bit, so I'll think of a few folks.
I think we do some brainstorming too.
Okay,
I'd recommend, yes, I'll give it to you, this, the school, as you'll talk about, not just my colleague that's in James, but also, someone that's involved, either a superintendent or, do you want to include daycares? Like, that's kind of, think about, that term, what that includes, universities. Does it include Norwich? Does it include, 2-year colleges? Probably not, but something to think about there.
for some reason in my head, I thought we had churches. And
I thought I did too, but I may have forgotten to add it, and I'm more than happy to add it.
yeah, I know we're not in markup right now, but just the mental note that I'm making. In my opinion, I think the churches should be added, but
I'm not
so
opposed
I
to
was
that.
thinking of clergy if you wanted to.
I will say that towards the end of the deadline, something slipped through the cracks as I was trying to approve a couple dozen bills.
All right. Anything else? Great. Thank you, Rick.
Yeah, thank you.
If we're going to hear from a superintendent, I'd recommend a superintendent. Some policies. sort of
Yeah.
similar to this.
You know them.
Yes.
Oh.
Quite well.
So next, we'll be having Eric at 10. So we've got 5 minutes. So we can go off the air and 6-minute break. Thank you. Thanks, Rick.
Yeah, thank you.
We just see the Russian backed tanker. That was really-
Okay, we're still live.
Yeah, I heard.
They're still live.
So there was a Venezuelan tanker.
We're still live.
Yes.
That's quite.
Okay.
Can't find the thing.
And headline news.
Just wanted to make sure you knew.
Okay.
I heard that there's.
Yeah. Like, remember we read.
Good morning.
Golf. I mean, it's crazy business.
I think there might be a button that just says.
Then.
That's why we find out.
There is.
Just, so you can let that tanker go.
Oh, I think we're live. Oh, we should be. Well, I guess since we're live, I can keep it there if we're not starting place. So, okay, so. Sorry. What the things I make backwards. So we're back. Is the camera working? Is there a try? No worries. Well, I see it. Yeah, that's close enough. So we're back in Senate Judiciary after a 5-minute break. We're going to S-178, which was introduced by me. This is a bill related to speedy trial rights. I won't do the full walkthrough since we have our attorney here to do that, but basically this is a change to our speedy trial rights, which is a law that is not really, that hasn't been updated in quite some time. It essentially creates a sort of procedure that creates some accountability when it comes to cases that have been pending for an extremely long time, and it's essentially a policy that will help in addressing our backlog. And well, actually, you know what? I'm just gonna pass it to Eric, and if you want to do our walkthrough and just go through the bits and pieces of it, that'd be great.
Sure, yeah, absolutely. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do my first walkthrough in this committee of the year. And as Senator Hashim was saying, it's S-178, which is an act relating to speedy trial procedures in criminal cases. As it's my first one this year, probably not last year, that when I do a walkthrough, a lot of times I take a minute or two, talk about some background, sort of ground everybody in a big picture of what's going on. That way it can be helpful when you see the details to sort of have that in mind when you look at it. So as Senator Hashim was saying, this is a proposal to enact some specific timelines for particular kinds of cases. So and it applies to nonviolent misdemeanors, nonviolent felonies. So a criminal charge of a nonviolent misdemeanor is not brought to trial within 12 months after the charge is filed, then you have an opportunity for the defendant to file a motion to dismiss. That's what the bill sets up. It sets up a procedure, a process, Senator Hashim was saying. With respect to nonviolent felonies, it's 24 months. So they have 24 months within which they can file this motion to dismiss. There's no result mandated by the bill. In other words, it's not a requirement that the court dismiss the case or that make any particular finding. It sort of sets up this process that would apply in speedy trial situations. And when you say speedy trial, I think a lot of times, first thing that jumps to people's mind is the Constitution, right? I mean, that, and appropriately so. The Sixth Amendment does specifically protect the right to a speedy trial. Sixth Amendment of the United States Constitution guarantees that right. But there are no specific timelines in the Sixth Amendment. There's no specific timelines in the Supreme Court case law that's come down under the Sixth Amendment. So states have been free to enact their own statutes. Some states either just sort of track the general U.S. Supreme Court case on this, which is called Parker v. Mingo, which sort of is a balancing test. Again, no specific timelines. But plenty of states, whether through court rule or passing statutes, like the one you see proposed in front of you, have enacted specific timelines. And that's what S-178 proposes to do. And yeah,
Eric, I just wanted to jump in regarding the administrative directive from the Supreme Court.
I'm going to segue to that
number
thing.
Oh, you were about to
No, please, you go first.
Yeah, so that was issued in December of 2024. So, the timelines that are provided in this bill are actually more, describing as more lenient compared to what our Supreme Court issued. And again, what our Supreme Court issued is guidance, not necessarily a requirement that has to be followed. But what our Supreme Court said is that all misdemeanors, violent or non-violent, have to be adjudicated within 180 days, and felonies, both violent and non-violent, have to be adjudicated within 1 year. And considering the backlog and considering what I think is a bit more fair, the timelines that I thought of this are a bit longer than what the Supreme Court issued. But yeah, just want to throw that out.
Yes, exactly. And I think as you mentioned, Senator Sheedy, the Supreme Court administrative order refers to them as guidelines or goals, it uses those words. So, but you're right, are not as strict as the ones that are in the Supreme Court administrative order. And as I mentioned, plenty of other states have done this, both similarly by court rule, as Vermont has done, or by passing statutes. This bill in particular, S-178, is based somewhat on a Massachusetts rule of criminal procedure, rule number 36, the Massachusetts rule. So I'll mention a couple of places where some of that stuff is directly from the rule. But sorry,
Is that a court rule?
Yeah.
You mean, okay,
Yeah.
so not a statute.
correct, in Massachusetts.
Yeah.
That's the way I've done it. But also, interestingly, not as, but also more strict than the proposal that Senator Sheehan has. For example, in the Massachusetts rule, it's 12 months for all offenses, not just nonviolent. So, for more violent offenses, you also have a 12-month time limit under the Massachusetts Supreme Court rule, subject to some extensions, which is actually one of the places that I've taken the language from the Mass Court rule. So I'll point that out when I go by. So there's always this ability. And it's a clear line, but there's also a long list of circumstances under which that time period can be extended. So in that extent, there's some flexibility here. But the other way that Massachusetts rule is far more strict than this one, this proposal, that's 178, is that the Massachusetts rule, if you don't meet the timeline, mandates dismissal. Case has to be dismissed.
Well, and that's a question that I had for you. Reading through it, it looks like everybody is, not obligated. Everybody, except a response is required,
Correct.
but the court may refer it to a hearing, may dismiss, etc. And does that have to do with separation of powers?
In a sense, yes. That the sort of concept of separation of powers does sort of underlay all of this, telling the court specifically how to handle a situation. But I think that I don't think it would necessarily be a violation if you decided that you wanted to say, for example, dismissal shall be required in a particular situation. But the approach of this bill is not to do that, not to mandate a particular result, but another sort of overarching principle that you've got that would underlie this bill, which is also incorporated. I'll point out where that is Rule 48 of the Vermont Rules of Criminal Procedure. And that permits a court to always dismiss any criminal prosecution in the interest of justice.
Okay.
And it's this overriding principle that would provide the court with the authority. Let's say, he follows the procedure that's outlined in the bill, hears from the prosecution, or assuming they respond, we assume they will, as we mentioned. If they don't respond, there is a specific about dismissal. But let's assume they respond. Court weighs the arguments and decides that it really isn't a valid reason for waiting for the delay. In this particular case, the court has the authority under Rule 48 to dismiss it in the interest of justice.
Even without this?
Correct.
And I'm thinking there was a judge in Northeast Kingdom, I thought it was, who dismissed a whole bunch post-pandemic, a whole bunch of cases.
I remember that.
Was that Rule 48?
I don't know. That's a good question. It might well be. It might well be.
Okay.
And I think if I remember correctly, there was even, in addition to that, I almost think that there was a time during pandemic when prosecution, defense, and court had all agreed on dismissing a bunch of cases for the sake of efficiency and the interest of justice, you might say. So there's in a couple of these leading Supreme Court cases on Rule 48 and when a court can dismiss, the Supreme Court has listed a bunch of criteria that the court could consider, and those are incorporated into the so that's sort of a reference to this court's inherent authority to do that. Which is an interesting separation of powers question,
Yeah.
Yeah.
So Eric, there was one question I was thinking of this morning regarding this. So let's say a nonviolent misdemeanor is beyond that deadline. They're at 2 years,
Right.
It is the defense that would file the motion, right?
Exactly.
And so the burden would still be on the defense to prove that it is in the interest of justice to dismiss the case.
Yes, I think you're right, that the first instance of what would happen when the defendant, let's say the defendant, as the bill gives them the right to do, files their motion to dismiss, the prosecution then does have a burden to explain why.
Yeah.
But you're right, that as far as dismissal goes, that's on the defense to say, or if they're gonna demonstrate to the court that it's in the interest of justice. Well, I think the court does, if I remember right, the court does have inherent authority to do that, so that even if the defense didn't necessarily file the motion, the court would have the ability to dismiss.
So this is just a note for the future, for markup. From my perspective, what my hope to accomplish with this is to have the burden on the state when it comes to proving that it's in the interest of justice to not dismiss the case. In other words, if there is a nonviolent misdemeanor that's 4 or 5 years old, I was looking at Windham County, the oldest one right now is from 2017, that is still active. I think it's reasonable to have a procedure that requires the prosecutor to explain why that case needs to continue. And my opinion that they have to explain why it's in the interest of justice for that case to stay on the calendar, or stay on the docket.
So I see what you're saying. And so could even add as a possible thing, thinking about markup, as you're saying. I'm just looking at page 2, line 4, but like now it's framed as response shall explain why the trial did not commence within the time period. You could add and why it is in the interest of justice for the case not to be dismissed. That's what the burden's on them to actually make that case. But that's just, it may be a better way to do that. But as you said, it sort of occurred to me it's one possible approach. So with that in mind, I think you probably understand just what's going on in the bill, but we can also take a look at where what we just talked about actually occurs in the bill, how it all plays out in terms of statutory language. So we could turn to a look at the provisions themselves, unless there's any more questions sort of before we do that.
That's good. Sort of a general one. What is the definition of like when it commences, a trial is commenced? Is it when it's adjudicated or?
In this case, I see. Well, you have the trial to commence within a year after the charges. So the clock starts ticking when the criminal charges are filed. And then that's a good question. Would it be, the handling of a jury? Would it be the first day of testimony?
It would likely be the panel.
That's what I think I've heard.
Good question. Okay, is coming in tomorrow, I believe.
Yep. But yeah, that nice segue, Senator Matos. Thank you. So that takes us to that language right there that puts in the statutory language. What we were just talking about, A1 and 2 on page 1 set out this timeline and how it works. Subdivision A1, the first one is about nonviolent misdemeanors. Defendant can move for dismissal if the trial hasn't commenced within 1 year after the charge was filed. Subdivision 2 is nonviolent felony. Can move for dismissal if the trial hasn't commenced within 2 years after the charge was filed. So that's your timelines are set out there. You turn over to page 2. Subdivision B1 at the top there. So, well, then what happens? Let's say the defendant files their motion. B1 says what has to happen next. Prosecutor shall respond to the motion within 14 days. So they've got a 14-day time limit to file a response. And the court may set the matter for hearing 2. Within the response, what does the prosecution have to say? See that line 3 and 4. They have to explain why the trial didn't commence within that time.
I'm sorry to stop you so soon.
Yeah, no problem.
When it says they may set a hearing,
Right.
If they don't, then what happens?
For example, the prosecution, whether the court sets a hearing or not, have to file a response within 14 days.
Yeah.
I'm supposed to. In theory, the court could make a decision or a ruling based on the papers. They're not required to set the matter for a hearing.
Well, what I'm thinking of is because we're dealing with the backlog. and
Right.
everybody's inundated and everybody's overworked,
Mhm.
including judges. So what if a judge just said, I'm not dealing with this crap. I'm not gonna respond to any of this. Do they just go away if there's no hearing set?
You mean if the prosecution, the defendants filed their motion and what
And the prosecutor
responded, let's assume they do, okay. I don't think a court would just ignore a filed motion. It's a question for Judge Zoning, whether that's ever something that the court would do, and I think that they generally require themselves to respond to any motion that's filed, but I don't want to speak for him,
Does responding mean setting the matter for hearing?
not necessarily.
Because I guess what I'm wondering is, could somebody who considered themselves overworked just say, well, there are gonna be delays, and I don't hold with this idea that I need to set hearings for these, so I'm just gonna ignore it.
They could decide not to set a hearing.
Yeah,
I think they would be institutionally and possibly under some other rule obligated to at least respond to the motion one way or another.
okay.
Even if it were to say something along the lines of what you're saying.
Yeah, I'm just wondering, given everybody's workload, and what we're trying to do, I take the purpose of the bill to be reducing the backlog by requiring that people, who have waited too long, have the court look at the matter and maybe dismiss them. But the conditional aspect of what the court can do seems like if they were overworked, it might. But I hear you now saying they might not set a matter for hearing, but they'd have to respond. And that would probably be an explanation of why they wouldn't set a hearing.
If they were going that route.
Yeah.
Yeah. Yeah. And maybe an explanation why they could choose to defer any kind of ruling if they wanted to.
Yeah.
And there's no, again, as I mentioned earlier, this overarching Rule 48 of the Rules of Criminal Procedure that allows a court to dismiss in the interest of justice is not a requirement. So the court could respond to the motion and the response by the prosecutor. However, it's up to set a hearing, not set a hearing.
Yeah.
Issue an order that says A, B, or C, whatever it might be. Okay. That sort of does require the process to sort of at least get started in motion.
I like the intent, but, okay, but my question is, and my concern is for, victims, for alleged victims. I don't see where really, I mean, it mentions briefly on page 3 under line 1K, the attitude of the complainant or victim with respect to dismissal of the case, but I'm concerned about what happens to victims if they suffer monetary loss or whatever else. Is this something that is the state just is unable to prove this? I guess there's no place for these victims to go after this is just done over with.
Well, assuming, for example, as you just said, if they suffered a monetary loss of some kind, they would still have their restitution proceeding.
Victims fund.
They could be compensated under their Crime Victims Restitution Special Fund or the Crime Victims Special Fund. They're two different ones. And I think there are some specific rules within the restitution proceedings, for example, that talk specifically about dismissals not having an impact on the ability of victims to obtain restitution or that how the ongoing situations where the offender has not paid their restitution, how that impacts an ongoing proceeding. So it's a good question to think about that interrelation and see if that affects this or not. I don't think it would. I think that those rights that a victim has under the victims' comp and restitution statutes would still exist, notwithstanding this, but I will follow up on it.
And I don't want to jump ahead because I haven't finished yet, but I thought Senator Booth was talking about SH filing a motion or whatever to the courts. Is this something that, because of the pandemic or whatever else, you're just congesting the courts now with the multitude of cases that are still hanging out there that file motions on these? Are these folks grandfathered in, or is there a starting date on this?
Yeah, so that was something I was going to bring up towards the end here is I think the question is unanswered. what I would like is either a prospective enforcement of this, because if the state, you know, let's say this passes and the state suddenly has 14 days to file literally hundreds of motions, that would be close to impossible, I think. So I think that having it apply either prospectively or creating some sort of tiered approach where there's a case that's, say, 3 years old, the state has 6 months to file a motion. If it's 4 years old, they have 4 months to file a motion. Could do something like that. But I think having it all happen at once would be insurmountable. So, yeah. So that's something that we'll figure out either towards the end or during markup.
Right. That reminded me that there was sort of a tiered approach in Massachusetts. Another way to think about that same idea.
Yeah. Yeah, thank you. Senator Meadows.
Just real quick, will we get Judge Zone tomorrow? You said?
Yes.
Is he gonna give us an update on the backlog? Like they did last year? At some
Yes.
point, maybe? Maybe not.
I did ask, if I recall correctly, for the general update from the judiciary, probably sometime next week or the week after, but we can bring that up again. Yeah.
Two other things that I'll just point out in the bill so you know where they come from. So we're on page 2 line, we just talked about response, what the prosecutor's response has to contain. You look at lines 4 and 5. This is the response may refer to any of the following factors. You see that on line 5, and then you have this list of factors. Those are 12 factors. Those are the ones I mentioned that the courts under a Vermont Supreme Court case called State v. Save from 1995. Those are the 12 factors that the court considers when thinking about a motion to dismiss under Rule 48 in the interest of justice. So the court already set out those factors. It's not an exclusive list, but that's where those factors come from. So it comes from that case. Those are the things, the kind of things that the court thinks about when it deciding should this case be dismissed under the interest of justice under Rule 48. Two other quick things over on page 3. You'll see lines 5 to 7. We mentioned this already. So if the prosecutor, for some reason, doesn't respond at all, then the court may specifically talks about a remedy there. It doesn't talk about a specific remedy anywhere else. But in that case, the bill says the court may dismiss the case with prejudice. That means you can't refile. Right? With prejudice, prosecution can't refile it. And then the last thing starts on line 8, subsection C. You can see, for purpose of this section, the following periods shall be excluded when computing the time within which the trial of any offense must commence. So you've got these 12-month and 24-month time periods, right, that generally apply. This is a long list of periods that are excluded. So if the delay happens for any one of these, basically 1, 2, 3 pages of reasons there, those don't get counted. And where that list comes from, that's the exact same list that was in Massachusetts Rule 36. So that's where that comes from. They use those exact same reasons to allow for the prosecution not to have met that time frame. So that doesn't say you have to include them all or any of them, but it's used as a basis for it. That's why it's there. I think that's it.
Yeah.
Yep.
Committee, any additional questions on this? We will be hearing from the state attorneys at 11. And actually, then have you heard back from Camille Roach from the Attorney General's office? Well, yeah. Okay, all right. So we'll also eventually hear from the Attorney General's office on this, and we'll figure out some other witnesses as well. There's plenty of time in on this.
Oh, the one thing I wanted to mention was when I was talking about these cases on Rule 48, there was the State Suave case, which 2 lead cases. The other one actually called State v. Fitzpatrick. Checked with my mother, no relation. So no conflict of interest.
Oh, yeah. Great. Okay. Thank you. Appreciate it.
You.
Turns out you have the dark path.
You always wonder about that wing of the family.
There's always one.
A few minutes early, we can I'll just get started with your testimony. Sure.
But this bill, prosecuting.
Talking about this bill, it was just, and we'll be talking about your bill, the speed trial.
That's what I meant.
Yeah.
Okay, good. So I was gonna listen to, but I was, that's what she was saying.
Yeah.
Great, thank you.
Yeah, thank you.
So I should change the time schedules. We're starting to. So should I stop the time schedule?
I don't know that you need to.
Is it up all the way?
Live stream, because I think when it appears on YouTube, it just shows the times and it takes.
It's just very squishy.
Yeah.
Finish it. Yes.
Yesterday, the appropriations, I was sitting.
I believe that's, yeah, I believe that's okay. And I've seen it for on other videos where it's
All the way down.
jump between bills in one block. So should be all right. I'm sure we'll find out if it's not, so. Okay, so we are now switching gears to S-208. We have Sophie Zidane from the Ledge Council here with us. This bill is related to law enforcement identification and masking. This has been a topic that sure all of us have heard about in some capacity or another. And it is something that we are addressing here now, the state of Vermont. So, Sophie, if you want to start with your walkthrough, we also do have this pretty handy chart here. Thank you.
My plan was just to walk through on this, and then I have a presentation in terms of the constitutional implications. So I'm Sophie Zidane for the Office of Legislative Counsel. This is my first time in this committee, so very pleasant to be here. I picked up this bill from the Judiciary team. I think had some changes in personnel. So again, as she noted, this is to do with anti-masking. Just a little bit of background, there have been some bills proposed in a number of different states around anti-masking for law enforcement. The only one that's gone into effect so far is the California bill. The one that this S-208 is modeled on is largely on the New York bill, which is called the MELT bill, which stands for Mandating End of Borders Tactics. There are other bills in Massachusetts, Illinois, Tennessee as well. So just by way of background, there has been a lawsuit filed by the federal government against the California bill, which went into effect on January 1st. The hearing on the federal government's bill is going to be held on January 12th. So as far as I'm aware, that bill has actually, it was passed in September, but it's actually taken effect as of January 1.
Okay, before we leave that, is there a stay on it, or is it considered in force?
I believe it's enforced because the hearing is on the motion to enjoin
I see.
moving forward.
Okay, and have they abided by it? Do we know?
I don't know, I haven't seen anything from the news on how it's laid out.
Okay,
It's the Ninth Circuit, right? For California.
It's in the district court
Okay.
at this point. So this bill proposes to do three things. So to require all local, state, and federal law enforcement officers
to clearly identify themselves by their name or their badge or both on their uniform. Also to prohibit law enforcement officers from wearing masks or personal disguises while interacting with the public in the performance of their duties. And then it does list some specific circumstances where masks are permitted. And then it provides a penalty for if you violate the law, if it goes into effect, would be a fine of up to $1,000 or loss of professional licensure certification for both. So that's just the overall goal of what this bill does. And that it would, this bill would be placed in Title 20 under the internal security and public safety provisions of the Vermont statutes under Chapter 151, the Vermont Criminal Justice Council. And so it would be a brand new section, section 2373. So at the bottom of page 1, it expresses the legislative intent and the intent of the General Assembly to exercise the power granted to Vermont by the 10th Amendment to the U.S. Constitution to protect the health, safety, and welfare of its residents and law enforcement officers present in the state by codifying standards for law enforcement identification. Subsection B, line 4 on page 2, it uses the definitions for law enforcement agency and law enforcement officer that are currently in state law. And then it adds onto subdivision 2, law enforcement officer has the same meaning as currently in statute, and then it includes officers of a federal law enforcement agency or any person acting on behalf of a local, state, or federal law enforcement agency. So that would include contractors as well. And then it lists in subsection C the identification requirements. So into subdivision 1, which is line 12, law enforcement officers will be clearly identified by the officer's name or badge number or both on the officer's uniform. Subdivision 2 is where the prohibition is on not wearing any mask or personal disguise while performing one's officer's duties with the public. And then subsection 3 gets into the exceptions, and those are the occasions when a mask would be permissible. So again, it lists out medical grade masks, respirators, and then at the top of page 3, smoke exposure in fire situations, water rescue operations, biological or chemical agents designed to protect against exposure to cold during weather emergencies. And then in subdivision 4, there's it separates out tactical services unit who are using gear that protects their faces when performing their responsibilities. And subsection B talks about law enforcement officers who are in acting undercover drug-related operations or assignments who may use a personal disguise when necessary to perform their assignments.
Can I just ask about that? So this administration has been very free with the use of fentanyl as an emergency that triggers additional powers across the board, including seizing Venezuela. But, on much smaller scale, they are saying, ICE agents have this power, president has this power, just because there's a fentanyl crisis. Could they, under this provision, say that, given the situation with drugs coming into the US, this entire arm of law enforcement goes masked every day?
So I don't know what they could argue. Obviously they can argue, choose what argument they want to make. The goal here is if you're working in undercover drug-related operations, generally the goal of this is really addressing more masking with in the immigration context. So again, if it's a criminal operation that involves fentanyl, if there are individuals involved in drug operations, then that might be legitimate. But if this is a question of somebody, again, I'm just echoing back to the earlier testimony you heard around civil arrests and things. If the goal is to pick somebody up in order to take them for an immigration hearing or removal or whatever, then that would not be an active undercover operation. So I think there would be arguments to be made on the other side if those were raised.
Okay. Thank you.
And again, the last section here is on penalty. So it provides that a law enforcement officer who violates this bill would be fined not more than $1,000 or lose their professional licensure or certification, or if applicable, both. And then it proposes that the act would take effect July 1, 2026. I provided a handout, which I know that I see that you have in color, mine in print and color. But, and the goal of this was because the two statutes that have been most discussed in the media in 2025 with the New York bill and the California bill, this was really to compare, the different bills. So I just wanted to highlight a couple of things. So under the definitions for the California No Secret Police Act, one of the arguments that's been made in the legal proceedings there is that the law is discriminatory because it includes local law enforcement officers and federal law enforcement officers, but it doesn't include the California State Police. That's not an issue with the bill that's proposed here. This would cover local, state, and federal law enforcement officers. It's not pulling out particular Vermont officers. So I just wanted to flag that for you. And then you can certainly see in the California bill, there is more extensive provisions, particularly around requiring law enforcement agencies to have a policy in place to say that they will be, following the rules on facial coverings. Just so that might be helpful to give them questions about.
That's great.
Let you know.
So I know you mentioned you have a presentation here, but before we go to the presentation, are there any questions on the bill itself?
I'm just curious about line 7F, a mask designed to protect against exposure to cold during a declared weather emergency. So if it's like cold out, it's not an emergency, but if I'm out snowballing my driveway, I'd probably
Where is that page?
page 3, line 7.
So this would be for law enforcement officers actually engaged in their duties.
Right, but if it's 5 degrees out, that's pretty cold, but it's probably not a declared weather emergency.
Yeah. Yeah, I agree with that. I think, I know we're not in the market right now, but just a note for the future. In my opinion, I think that it should necessarily be a declared weather emergency. I think that, if there's, search and rescue on the side of a mountain looking for a lost deer, they're all probably going to be wearing masks. And so I think we can wordsmith that, but thanks.
I was just curious.
Yeah.
If there's a definition. Good catch.
I mean, one of the issues with that, I think, is anyone trying to influence this, just mentioned in terms of, well, it's cold. So I have it's Vermont, it's cold, I have a mask on. So that would be something to think about how you would craft that so it's not too broad. Down the line, the intent of it, though.
And then I'm just curious on line 17 there with the penalty. It says $1,000 fine or lose the officer's professional licensure or certification, if applicable, or both. So that means like losing your professional licensure or certifications wouldn't apply to a federal agent because state of Vermont doesn't have the ability to.
That is a question that, for the committee to think about is what the enforcement mechanism would be. This bill were to advance, because there would be restrictions on the ability to impact federal officers' licensure or certification.
Could they get fined as well?
Yeah, it's a good question. Obviously we wouldn't be able to, make any administrative changes regarding licensure of a federal agent. Although it's possible that there could be a recommendation to do so in the Vermont Criminal Training Council for a state or local police officer or deputy. It doesn't necessarily mean that is what would happen, but it is possible. Senator Mahosky.
I just wanted to verify, and you just did for me, that this doesn't only apply to federal agents, it applies to all law enforcement operating in Vermont.
Yes.
And I would assume we'd be able, to your point, to fine someone that was operating in the state, say a federal agent.
Yeah, I think bigger question that we would have to, have a lengthier conversation about. The question that was, swirling around my head earlier was, so for example, if a federal agent happens to be drinking on the job and they get a DUI, they're not exempt from, the criminal charge, because obviously drinking on the job has nothing to do with federal law enforcement. However, I think that the federal government could likely make an argument saying that you can't impose this penalty for federal agents wearing masks because they're, them being anonymous is necessary for their law enforcement duties and what they're doing. That's what I suspect they would argue. And so that's the constitutional question that we have to chew on for a while.
I think there would need to be some mechanism put in onto how you would handle it if the federal law enforcement office, because again, this would be under the Vermont Criminal Justice Council, so they would have authority to address for a local law enforcement officer, but there's a gap there in terms of what the enforcement mechanism is.
So this, yes, well, is it, well, actually, I should ask the attorney, but civil in this context?
That's, at the moment, it's, yes, it would be, it looks like you had mentioned a civil penalty, but it's above $2,000. And again, if you look at what New York and California have done, New York, it provides that it would be a misdemeanor, punishable as a misdemeanor, and then in California, it's a willful and knowing violation, punishable as an infraction or misdemeanor. And then criminal penalties not applicable if the law enforcement officer was acting as an employee of an agency that has a written policy. And then they also provide in California, the law would remove some of the immunity, privileges and immunity that a police officer might have in terms of if they're charged with a false arrest or, tortious conduct. So they have a different approach. So this is different than New York and California.
Yeah, and I think the issue that we could potentially encounter is if it is a criminal charge compared to a civil charge, like essentially a traffic ticket. That's where I think the challenges could arise, but we'll be having more conversations later.
Seek to share.
Senator Wilson.
I have a tangentially related question that you may not be the right attorney to ask, and that is, what is the penalty for not paying an administrative fine, or is there one?
I'm not sure.
Okay.
They have another 5.
Yeah. They go to the back one. Sorry, please.
Yes. So this does raise some constitutional issues. I'm sure this committee is familiar with with a lot of the constitutional issues I'm going to mention, but I just thought it might be helpful to go through that. So just.
Don't do anything.
Yeah. Having different type of issues. Okay. So the first was to talk about the 10th Amendment. Sorry, I put it on top of me. The 10th Amendment, which is mentioned in the statute, in the bill. And that essentially provides that the powers retained by the state and the people are those powers that aren't specifically delegated under the US Constitution. So essentially any powers that aren't specifically given to the federal government and not explicitly withheld from the state are reserved to the state. So for example, things that are specifically delegated to the United States are things like coinage, clearing war, regulating interstate commerce. But the state has the ability to regulate whether Constitution doesn't reserve those powers to the federal government. My button's gone off. Okay. Anti-commandeering is when the Supreme Court, when the federal government tries to force the states to do things. So there's kind of a balance between anti-commandeering and then what we'll talk about later, which is intergovernmental immunity, and that kind of opposite sides of the same coin. So on the one hand, the US can't force the states to do things, and on the other hand, the states can't forcing the federal government to do things. So anti-commandeering here, and again, just to talk about it in the immigration context, would be things around sort of forcing states to enforce federal immigration laws. And there's extensive decisions on that states have the option to assist ICE, but they're not required to do so. And I know you had last session, there was a bill around 287G contract. So again, those are agreements that states can voluntarily enter into with ICE, where they can use their local state law enforcement to assist, but there's no requirement for states to do that.
Can I ask? Oh,
Yeah, please.
so commandeering, one of the tools the federal government seems to be allowed to use is withholding federal money unless you do bags. That doesn't fall under the Supreme Court's definition.
So there's cases that go in different directions on that. So it can depend on how much money. So if it's, the federal government's going to withhold 10%. We have a case on that, a Vermont case from a while ago, but where the federal government was going to withhold 10% of the transport. And the Vermont court held that in the big scheme of things, the whole size of the budget, the amount of money that was coming in from the federal government to support transport, that was not a violation of anti-commandeering.
So it didn't rise to the
Didn't rise to that level. But again, this is a hot topic right now. I mean, I think these are all questions that are going to percolate up.
I'm thinking about gender affirming care. And there are a series of threats out there that if a state continues to allow gender affirming care, the whole raft of health and human services money will be cut off. Seems like what you're saying is the argument for Vermont would be that scale and scope reaches the threshold there.
And there is a Second Circuit decision that dealt with grants. And there was an argument that where states were saying, well, we're being excluded from these grants because we've got policies that the federal government doesn't agree with. And Second Circuit, which is the circuit that governs Vermont at the federal level, held that it was the grant, so you're free not to take the grant. So, again, there's law out there, but this is definitely a gray area that's going to be percolating up, particularly right now. So, yeah. So this bill really is not getting into this issue. I just flag it because it's in the mix of the constitutional issues around immigration. But here, the bill you have 208 is not implicating, this is a bill that you would be doing, not something the federal government is seeking to have Vermont do. I can get to the next one. Okay. And then under Vermont's constitution, we specifically have in our constitution, chapter 1, article 5, the state police powers, so that the people of the state have the sole and inherent exclusive right of governing and regulating the internal police of the same. So although this bill is specifically talking about law enforcement, the police powers generally are the power to govern. It's not limited to police. So that's just a coincidence here, but essentially, the state has the authority to pass laws that they believe are in the best interests of the people of the state, for the health and welfare of the state. And so that, I think, is part of the reference here with the legislative intent, is referencing the 10th Amendment, and then looking at specific language on the legislative intent is to protect health, safety, and welfare of the residents and law enforcement officers present in the state by codifying the standards, identification standards.
So, okay. Thought of, one question regarding severability. I see that that this bill would, well, any bill or any act is covered by one VSA 215. Is there, so let's say hypothetically, it's found that this can't apply to federal agents. Do we have to change any of the wording so that it will continue to apply to all other law enforcement in the state? Because I'm seeing that we have a, our definition there on page 2, line 7. Actually, no. So it does spell out, and it does differentiate between local, state, or federal. So I think I just answered my own question there.
But I think essentially what would happen is if it was held unconstitutional for the state to regulate federal law enforcement officers, the law would move forward as it being applicable to our state and local, but it wouldn't apply to federal.
Thank
So switching to on the federal side, there's the supremacy clause of the US Constitution. Again, and this essentially provides that where there's conflicts, and we'll get into this in a second, but that the federal law is the supreme law of the land. And so typically what the US Supreme Court has done is they've done this through preemption, which I'm sure you've heard about before, but there are 3 types of preemption. So there's express preemption, which is when the federal law explicitly says we're in charge of this, and the states can't regulate this area. Field preemption, where there's just such extensive regulation on the part of the state, on the part of the federal government, that there's no room for the states. And then conflict preemption, which is essentially when it's impossible for someone to comply both with federal law and with state law. There are a couple of arguments that can be raised that derive out of the supremacy clause. So one of them is supremacy clause immunity, and the other is intergovernmental immunity. So supremacy clause immunity is essentially prohibits states from undermining federal law by prosecuting federal officials who are properly carrying out their federal duties. It cites here an 1890 case because the Supreme Court has really not addressed this particular immunity for over a century, but the lower courts have, and so they've evolved this 2-part test that's shown on the screen. Interestingly, here in this particular bill, you're not talking about criminal prosecution at this point, so I don't know that an argument could be raised that this is a violation of the supremacy clause immunity. But essentially, if you did have criminal prosecution, or federal law enforcement officer was potentially exposed to a criminal prosecution, the 2-part test is, was the official doing something authorized by federal law? And so both of these would have to be answered as yes in order to avoid prosecution. Were the official's actions necessary and proper to fulfill their federal responsibilities?
Senator Post.
Is there a definition of necessary and proper, or is that subjective?
It's, yes, that kind of is situation. These are very situation dependent provisions. It's just very hard to move this around. Decided to work. Okay. So looking at that, is there authorization for federal law enforcement officers to mask? There is no current federal statute or officially enacted policy or rule that explicitly authorizes or requires masking by federal officers. So one argument is no, there's no federal authorization to mask. On the other hand, officials with Homeland Security have publicly stated that they're leaving it up to individual officers to choose whether to mask. So the other side could argue, well, yes, there is authorization because the Department of Homeland Security has said we can choose to do it.
But have they publicly stated it, or is it a rule?
There's no formal rule, but there have been statements by Christine Nome and other people within the Department of Homeland Security.
But wouldn't we still have authority if they haven't expressed it as a rule or a statute?
Well, this would be the argument if you were getting into this, the argument on that 2-part test would be, are they engaged, are they federally, are they authorized to do this?
Right.
And the argument would be on one side, no, because there's no statute or rule that requires them to do it or permits them to do it. And on the other side, well, we're being told by our supervisors that we can.
Yeah,
And as far as identifying oneself, because that is part of this bill as well, the National Defense Authorization Act does require law enforcement to visibly display their identity and the name of their agency when responding to a civil disturbance. And then ICE agents, under current regulations, are required by law to identify themselves as immigration officers at the time of an arrest.
because it seems like I've seen film of a number of these arrests where they refuse to identify themselves and still take people in custody. So I assume those are being litigated individually when they happen.
Yeah, I mean, that someone's deported and removed from the country, and I don't know what action they would have to
Right.
do it at that point.
Senator Miles.
Just along those lines that, there's a video clip or whatever. I don't know if you know the answer, but they're required to identify themselves how many times? Like, if the video doesn't start until after the ICE agent says, I'm so-and-so with ICE, then the video starts. Every time after that, if they're asked, do they have to answer? If they answer it once, is that satisfy the requirement?
So the regulation says at the time of the arrest, the designated immigration officer shall, as soon as it is practical and safe to do so, A, identify himself or herself as an immigration officer who is authorized to execute an arrest, and B, state that the person is under arrest and the reason for the arrest.
Okay.
That practical and safe clause strikes me because the argument that's been coming down from Homeland Security is that the masking is necessary because otherwise these people will be doxxed and they'll suffer consequences for the operations that they're lawfully doing. Which is true in a way. There are people out there looking to identify ICE agents who are going masked. So I have seen online where somebody takes their mask down for some reason, screenshot, and then that person is identified and moved around the internet. But it seems like then you're just getting rid of that whole piece because anything would be protecting your identity or for safety.
Yeah, I mean, that's certainly the argument that's been raised by the federal government, both in the media and then in the California case, that they have to do it for this reason. So.
But it seems like that just undermines the whole statute. Because in this day and age, anybody could claim that their identity makes them vulnerable to online retaliation.
And there certainly have been stories of impersonation. That's the other piece that gets back to the health and safety and welfare is, there definitely been stories of people impersonating ICE officers to kidnap people. And, right. So, yeah.
So that part, I think it was at the end of the definition there, when safe to do so. Could you make the argument that when the individual's back in the car, that is when the officer feels it is safe to do so for the exact reasons that Senator Ruth brought up?
Yeah.
With that, like argument that they would make.
Somebody could make that if
Yeah, never quite to.
Does it happen? I don't know.
Yeah.
But
and I think what is differentiated here with our bill is that this doesn't necessarily require an officer, ICE or otherwise, to verbally say, I'm Officer so-and-so with ICE, rather requires that there is some form of identification on their uniform, and without a mask, unless it falls into the exceptions. But I'm not, does that second bullet point require them to be verbally identifying themselves and taking that time to do that?
Yes, it says identify himself or herself as an immigration officer who's authorized to execute an arrest.
And compared to ours, is it correct to say then that this bill doesn't require necessarily a verbal identification, but does require that they have something on their uniform? Thank you.
not the we'll go further down this hole, but civil disturbance, is that covered by like a nice?
So that is a separate statute, and I can look further into that, but this is just in terms of where federally law enforcement officers are required to identify themselves. And that is one of the areas is under the National Defense Authorization Act. And that's all federal law enforcement. And again, I don't recall off my head if it hasn't.
Oh.
But I can double check on that. But the only one that's specifically with ICE, there's a regulation, and that's the language on the bottom.
Okay.
And there's no, there's nothing in the regulations for ICE officers that talks about masking or not masking. It's only, this is the only piece. Seems like they're asleep. There we go. Yeah. All right. And then intergovernmental immunity. This is the other defense that comes up under the Supremacy Clause. And this bars state and local laws that either regulate the United States directly or discriminate against the federal government and those with whom it deals. So again, that California bill excludes the California state police. So that's one of the arguments the federal government is making in that case, is that it's discriminatory because it's not covering all California, that's sort of singling out, you know, as local California law enforcement officers. And then regulating, so direct regulation, you know, again, what likely the argument would be is that it constrains the agents in performing their employment. There is a case out of the Supreme Court back in the 1920s that said where the US hasn't spoken, state law can validly apply that affects incidentally the mode of carrying out federal employment duties. So again, you had referenced earlier, Senator Hashima around like being drunk on the job, whatever. I mean, there are certainly you can have state laws that apply to federal officers when they're acting beyond the scope of their duties. So the question that this bill raises really is going to go to how incidental is the bill to carrying out those federal law enforcement duties. And again, there's a case out of the Seventh Circuit from 2022 that held that laws that discriminate against the US can be constitutional, even if they indirectly increase costs, provided that the law imposes the costs in a neutral and non-discriminatory way. And again, I don't know here that cost would be an argument, but in that particular case, it was to do with not allowing ICE to take over facilities and not. And there was a state law that said, no, you can't do that. And then the argument was, well, you're discriminating against us. And it's like, no, it may cost you a bit more to, house people elsewhere, but we could do that.
But the discrimination against federal government wouldn't apply here because this is applying the whole law enforcement, right? Okay.
It would really be more that first question, whether you're regulating the United States directly.
Thank you. That's a helpful presentation. Maybe do we have any questions for that council?
I don't think so. I got one question. I don't know who's for it. So in doing the walkthrough, reading the existing law, I don't know of any law enforcement officers in the state, locally, state police that mask themselves.
I do.
Not aware of that, okay? And you can have your peace afterwards. So are we, if someone says, if it says ICE across their chest, or if it's just ATM, whatever they say, and they verbally identify what agency they're from, whatever else, have they met the criteria under this bill, or is this just a mask bill? If they don't take their mask off, they're in violation. That's that what we're looking at?
It has two pieces.
Two pieces.
So it's both. One is identification by your name and your agency, and then or name and badge number. And then the other one is the masking piece. So there's two pieces to it.
So in looking at the 10th Amendment, I'm wondering by them still having a mask on, At what level did that rise to the protection and safety of public here just because they have a mask on? I understand identifying yourself. I go at 100% here. But what threat is being imposed because they have a mask on?
Well,
Interpretation, like, would be a big thing here.
I don't know if that's necessarily a question for ledge council, so.
I'm thinking somewhere in there, there's a whole, this comparison chart. So from California, for instance, the arguments are listed like this. Routine use of facial covering by law enforcement has significant implications for public perception, et cetera. Facial coverings limit nonverbal communication, increasing risk of conflict if escalation, et cetera. So there's 6 rationales for how it affects public safety.
That's California, correct?
Right, but
It may challenge constitutionally.
Not because of the legislative intent, because it is discriminatory based on the exclusion for California state police.
And also that it's a direct regulation, it's interfering with their ability to carry out the. Yeah.
So, I mean, I think there are a number of arguments that suggest themselves to me, one of which is that we don't, in America, we don't have masked agents who don't identify themselves and force people into cars. When that happens, people, I think, are right to be alarmed and confused and to try to fight or stop that from happening. And that risks escalation, people getting shot, et cetera. So I think normalizing masking and not identifying is normalizing a situation where risks are greater than they are today. Public safety risks. I was.
Quick interjection here. Is Kim McManus on the Zoom? I just don't want to go over into her. She's not on this. Okay. Any other questions?
I will simply add that I do know of at least one instance where local law enforcement was masked and in fact did create quite a bit of public concern. And so I am aware of this. Obviously, law enforcement.
Can you tell us what the example that was, or?
It was a Williston police officer, and I've spoken to the chief of Williston Police, and they dealt with it quite well, actually, quite clearly stating that while not in their uniform code, will be added because they are completely against that behavior for all of the reasons that Senator Baruth just stated.
Thank you.
Mhm.
Thank you for your testimony. I'm sure we'll have you back in as we move along with this bill.
Good to see you.
Thank you.
Well, I do have a question, but not ready for this.
We can take a break until Kim shows up to talk about the speed trial bill, and we can go up to this.